What do you think? Adam?
How will you just stop?
Oh, there you go, figures. You didn't bet that. All right, then, so you gotta.
I'm gonna pay them.
Well, I don't bet them the same time. You need to stop paying cents and give him some medicine. You up and down.
I can't do everything one
Don't bring
time.
no other calculator.
I have medicine for salad. When I done finish bathing, I just do them.
Now you under arrest. You under arrest. You under arrest. No boys can move. Big boys can't move. Big boys can't move. Can't move. No frosty ain't going nowhere. He ain't going nowhere. He ain't going nowhere. Come here. I tell you. He ain't going nowhere. He ain't going nowhere. You ain't going nowhere, but you ain't going to this bed. Go terrorize my woman. You ain't going nowhere. Ready?
Ready?
Ready? You ain't going nowhere. Get up on me. Get in the
You know what?
I can see through that. You ain't going nowhere. You ain't going.
Good afternoon, everyone.
Okay. Just take one.
Good afternoon, Ms. Archer.
Y'all sound like a lively crew today. Like y'all have plenty to talk about. We're nearing the end. Next week is the last class. You getting excited?
Yay.
No, ma'am.
Tell me what you mean, no, why? Why not?
Because we still having some issues with the let's see, the time the test is supposed to be, because I'm still having some issues with that. I think I left the message for a certain party to give me a call back, and I still waiting on it. So I don't know. I guess they
Party
still
didn't
really
call
got
you?
something. No, I guess he still has something against me. So
I'm going to send a message right now to that certain party.
thank you, madam, because I still need to know exactly what the status is, or when, or at least to confirm, because now I'm being told something else by the office. So
Okay, let's see. Wasn't it pushed back?
yes, ma'am. I think I'm not certain. I'm not certain where. That's what I'm saying, because he sent an email for one date, And then I think I called the office, and then the office said that it's supposed to be after the fact. So I'm not certain, but so I still was trying to figure out because I don't want to disappear and go off and then still have
Yeah.
to sign it over me when I come back.
No, you'll do it before you go.
Yeah, if anything, yes, ma'am.
Okay.
Yeah, they said it's the 23rd and that anyone with outstanding fees have to be paid by the 14th. So there was never any mention of the 9th anymore. So I don't know if that.
I think he sent something saying that was not available. Did he say?
No, he didn't. That's the problem. So that's why. Well, that was one of the things, but I wanted to confirm with them, or at least for them to let me know. But like I said, I still waiting on the call, so I don't know.
Let me see if I see anything in here, because I gave him. Okay, let me see. That would have been last week sometime. I looking now to see if he sent anything out. Let me see. Okay, that's the wrong chat. That's a different class. I could have sworn he sent something. That must have been for another class. Okay, well, I sent him a note, so let's see what he comes with. He should answer. Let me ask him if you want me to ask him if he could come on.
Yes, ma'am, that'll be good because I can't get no calls.
Okay, I send him now, since he's on. Okay, let's see if he says yes before we start. He's online, so I just want him to say yes, which would be good. No answer. I don't think I can call while I'm on this call, right?
Not certain, ma'am. I'm not certain, but I like again,
No,
like I said.
no,
So
it's a no.
all right.
Unless he's talking to someone that says, I tell him class is waiting. Okay, let's see if he comes on. All right, let's get started. Hopefully he'll butt in. I'll see. All right, so today's class is on legal and credit risk. And it includes a part of the chapter we did previously on the bankers and customers' duty. But we're looking at it in terms of the relationship now between the client and the financial institution. So when you look at the relationship between the client and the financial institution, it is a relationship that is built on service. And there are three legal components to that relationship. It's contractual, it's fiduciary at times, and it is professional. So contractual would have been the chapter that we did earlier, where it spoke about when you enter into an agreement for a loan, the banker-customer relationship is based on a contract. And in that contract, there are implied terms and there are express terms. Those implied terms can be found in common law because they're not written anywhere. Those are the duties that arise naturally based on the relationship. And of course, once you're in a banking relationship, there are other contracts that govern other aspects of the service that the institution provides. So in addition to the duties and the obligations that are owed by the bank to its customer, there are certain duties that the customer owes to the bank. Hi, Miguel. Miguel. No, he's still not answering. I thought he was coming in. No, still not coming in. Yeah, so the customer has its duties and obligation, and so does the bank. And those duties and obligation, besides being express or implied, they can also be statutory, or it could be a part of custom. But in all in those duties and obligations, liabilities can arise if there is a breach of those duties and obligations because it is based on contract. So in addition, when you look at a contract in financial services, in addition to the express terms, and of course the implied terms by common law, there have to be other provisions within the contract, such as your rights, whether there are any indemnities, any protections. Hold on 1 second for me.
Yes, good evening, ladies and gentlemen. Your exam is on April 23rd at 1 p.m. at the Institute. Okay, we'll follow strict protocols via COVID-19. Okay, so we'll have you guys spaced out, but we can start at 1 p.m. at the Institute. The reason why we have such a late class exam is that we have end of semester for other classes, and they're doing it on the 9th, and then the Easter break is on the 16th. So we don't have any classes then. So April 23rd at 1 p.m. will be your exam.
Recording.
Any questions?
What about the persons who ain't gonna be here around that time, like me?
Okay, well, I will do an exception for you. Because I don't have space on the 9th to do the exam, you see? I really don't have space. So folks, please work with me. I can only do y'all on the 23rd. So Ryan, you can come on the 9th, but it'll have to be like about 1 p.m.
Okay, if you ain't got no space,
Freeport
if you ain't got no space on the 9th, you got space any other time during the week? The 4th, the 13th, the 12th, the 11th.
All right, send me an email. Send me an email. But you know what I mean? I'm going to keep everything. Send me an email to give me a time. If it is during the week, it'll have to be before. You'll have to do it in the morning because we close at 4. We don't have classes in the evening.
All right, that's not a problem. I just need to know. At least make an arrangement to do it if that's the case. But I just want to know.
Okay, so
So you said they'll send you an email?
pop me an email, and then we'll sort the time out. But ladies and gentlemen, please, everybody else, I need you to do it on the 23rd, please, at 1 p.m.
Any more questions before Miguel leaves?
Will he answer the emails? Because I know he is extremely busy.
You know,
He copy me on the email.
you again. Yeah, I'll answer your email.
You see what I say?
Okay.
Mr. Archer?
Yes, I'll answer your email.
All right, thanks, Miguel.
Copy me on it, Ryan.
All right,
Copy
then.
me. Like I could track him down in case he's too busy.
Yes, ma'am. I shall.
Yeah. Okay. Anybody else need to take it early?
All right.
No.
Yes, I need to take it early as well, so I'll send Miguel an email.
Okay. Yeah. So we probably take it the same time as Ryan does.
Yes.
Okay.
Yes.
Nobody else? Speak now. And don't look so, Miguel. All the rest coming on the 23rd.
Okay, great. Thank you so very much.
Okay. So Farrington and Ryan, copy me on email when you send it to Miguel so we can coordinate it.
No problem. Thank you.
Okay.
Okay, ma'am. Thank you.
Thanks, Miguel.
All right.
Okay.
All right.
Now everybody happy?
Yes, ma'am.
Okay, good. So going back to the contractual duties and obligations. So the contract, like I said before, contains express, and of course there are implied terms. You have rights, you have indemnities, you have protections. You also have legal safeguards with regard to the banker-customer relationship. So once you're in the banker-customer relationship, there is certain duties, and the banker has to exercise that duty of skill and care and attention. And that has to do with how he performs his day-to-day activities. And what is expected from him is what a reasonable man would expect in carrying out his duties. Now, once you are a professional in that banker-customer relationship, you are held to a higher standard. The next duty that they have as a banker is to act as a fiduciary. So a fiduciary is not a normal contractual obligation for bankers. It normally arises when the bank is undertaking to provide certain advice to the client. Investment advice, financial advice. So in the case of Bristol and West Building Society versus Morthau, it defined what is a fiduciary. And that is someone who has undertaken to act for and on behalf of another in a particular circumstance. And when that circumstance arises in which that banker is acting on behalf of its client, then there is a relationship of trust and confidence. And that trust and confidence means that you have the requisite skill and care to carry out that function. The distinguishing obligation of a fiduciary is that obligation of loyalty. And the principal is entitled to have the single-minded loyalty of his fiduciary. So once you act as a fiduciary, there's certain things that are inherent in that title. One is you must act in good faith. You must not make a profit out of the trust. You cannot place yourself in a position where your duty and interests conflict with whom you're acting on behalf of. And you cannot act in your own interest and for your own benefit or the benefit of a third person without the consent of the principal or the person for whom you're acting for. Now, every breach of a fiduciary duty implies disloyalty or infidelity to the client. It doesn't have to be dishonest, but it has to be intentional. In that same case, the judge expounded by saying the duty to exercise reasonable care is not specifically a fiduciary duty. An agent is bound to exercise reasonable care and skill, but failure in this respect does not constitute a breach of fiduciary duty. Mere incompetence is not enough. So in the case of National Westminster Bank and Morgan, the banker-customer relationship is not normally a fiduciary one. And in that case, it did not give rise to a presumption of undue influence. So a fiduciary relationship is only presumed and legally develops if the bank expressly acts in a manner that may attract that presumption. That is, by its actions. It assumes a role, a fiduciary role, in relation to the customer. And like I said before, it's like providing investment advice or lending advice outside of the scope of the duties to the customer and standard products and services. And that's why you have to be so careful when you provide advice. Because one, you could be acting as a fiduciary, and two, you can be sued for negligence if that customer relies on the advice that you give them and they incur a loss. The third one is professional relationship. And that professional relationship and duty of confidentiality go hand in hand. The conflict of interest obligation and the contractual and fiduciary duty not to disclose or use confidential information belonging to a client may occur in the context of the duty of confidentiality, which must be observed, upheld, and protected by the financial institution. Now, the common law statutory duty of, and the common law and the statutory duty of confidentiality in the Bahamas, and in particular to the banks and trusts, relative to their clients, has been one of the hallmarks of our financial services. So even though we have passed a lot of legislation with regard to register beneficial owners, CESRA, FATCA, CRS, that duty of confidentiality is still a hallmark of our financial center. The duty of confidentiality is generally an implied term of the banker-customer relationship. So that means that once you enter into that relationship with a client, by law, that duty of confidentiality arises automatically. Here in the Bahamas, we've enshrined that in our local legislation. So under section 77, you can correct that in your manual. Under section 77 of the Banks and Trust Companies Regulations Act 2020, the common law principles outlined in numerous English and Bahamian cases involving the duty of confidentiality in banking and other financial related matters have provided the legal framework within which the concept of bank secrecy in the Bahamas has been observed, practiced, and ultimately preserved. So even though you may say, and a lot of people say that that duty of confidentiality or that secrecy has been eroding, our law enshrines what can be released and what cannot be released. And I'll tell you, when banks have to release information, they normally seek a legal opinion, making sure that they're not sued in the end because they have breached their duty of confidentiality. The duty of confidentiality is a contractual one in nature and is presumed as mentioned earlier, upon the express and or implied terms of the banker-customer relationship in the establishment of the relationship between the banker and the customer. The duty is a fiduciary duty, which a banker owes to the client, and upon which he can be sued for breach of contract, for unlawful or unauthorized disclosure of information to a third party, inclusive of spouses, relatives, other financial institutions, and other unauthorized parties. Everything depends upon the nature and the scope of the banking relationship. The duty of confidentiality does not apply only to a customer's account information, but it also extends to information relating to a customer's identity, their assets, their liabilities, and financial affairs generally. However, there are some exceptions to this duty of confidentiality. In the common law case of Turnier, it was established that the bank has the duty not to disclose a client's information to a third party. If the bank does, then it breaches its duty of confidentiality. So the 4 exceptions to when a financial institution can disclose information of its client is when it's under compulsion of law, or when it's in the public's interest, or when it's in the bank's interest. And lastly, if you have the express or the implied consent of the customer. Compulsion of law means that when you have a request from the Attorney General's office, a request from court, or you're filing a suspicious transaction with the FIU, or you're filing a matter with the police. All of those are under compulsion of law. In the public's interest means that there is a matter that has come to the bank's attention, and they're going to file a report with the regulator so that the regulator can make a general notice that they have seen some discrepancy that may impact other account holders or just customers in general. In the bank's interest, if the bank sees that based upon the actions of a certain client or a group of clients, that the manner in which they are transacting business will be detrimental to the bank itself, they can actually disclose that information to the regulator in their own interest. And with the express or implied consent of the customer, that is based on the contract that the customer signs with the financial institution. And that's why you should always read the fine print, because you could actually be authorizing the bank to provide information on your bank account. So with regard to the disclosure of clients' banking, financial, or other ancillary information by Bahamian subsidiaries to their parent banks, domiciled in a jurisdiction outside of the Bahamas. In the case of Bank of America Trust case, a notable Bahamian case on the duty of confidentiality, it emphasized the fact that a Bahamian court will not condone attempts by a foreign court to pressure a bank licensed in the Bahamas, but having its parent company in that foreign jurisdiction to violate the bank confidentiality laws of the Bahamas. In presenting his decision in the foregoing case, Chief Justice Sabola cited the dicta of Lord Denning in the English case of R versus Grossman, which stated clearly that branches of the same bank in several jurisdictions were different entities separate from each other, and therefore subject to and governed by the local laws of the country in which they are domiciled. So it's highly recommended that a carefully drafted waiver or indemnity clause be included in the terms and conditions form of a bank account. And it should be signed by the client in order to obtain that express consent of the clients to allow confidential information to be vetted by a third party, even if that third party is the parent. Tony, you have a question? It is only by this means that such information will be able to be disclosed legally to a third party under one of the 4 qualifications, exceptions of the duty of confidentiality. So under section 77, subsection 2 of the Banks and Trust Companies Regulations Act, it does allow information approved by the inspector of banks to be transmitted from a licensee under the Banks and Trust Companies Regulations Act to its head office, to a branch or subsidiary outside of the Bahamas. And the purpose have to be solely for carrying out collation, synthesis, or processing of information on behalf of the licensee. So the names of the client does not go with the figures. It's just the balances. So the Banks and Trust Companies Act also allows the governor of the central bank to provide information on the beneficial owners, the directors, the officers, and operations of a licensee to a supervisory authority, which is responsible for regulating the head office of the licensee. And that's for the purposes of consolidated supervision. The governor also has the power under section 77, subsection 6, to provide the foregoing information to domestic regulatory authorities specified in the second schedule. Any breach of the statutory duty of confidentiality is subject to a fine of $25,000 or 2 years imprisonment or both. Any questions so far?
Good.
So the duty of confidentiality and data protection. So in addition to that duty of confidentiality, we have the data protection laws. And they actually were enacted to protect the privacy of personal information on individuals, in particular consumers locally and jurisdictionally. The Data Protection Act is based upon the privacy principles established under the OECD guidelines on the protection of privacy and trans-border flows of personal data. The Council of Europe Convention for the Protection of Individuals with regard to automatic processing of personal data, the Swiss federal law on data protection, and a compendium of data protection legislation from several European and Commonwealth countries. Now you have to be very careful when you're dealing with information relating to persons from other jurisdictions. You must not only know the Data Protection Act of the Bahamas, but if you have clients from other jurisdictions, you have to know the data protection laws of those jurisdictions also. Because you have to make sure that you do not break the laws in that jurisdiction. So following the OECD guidelines on the protection of privacy, one of the primary objectives of the Data Protection Act is to ensure that information is obtained by fair and lawful means, and that it is used in a manner consistent for that in which it was collected. So under the Data Protection Act, persons collecting and using personal data on individuals are required to observe and abide by specific standards of confidentiality in respect of such data. And they are prohibited from transferring personal data to jurisdictions with less stringent data protection. So they're talking about when you have information and you are storing it outside of the jurisdiction. Their data protection law must be comparable to the Bahamas. And you cannot do it without the consent of the person from whom the data is obtained. So there are several important definitions in the Act that you should be familiar with. Data, of course, means information in a form which can be processed. Personal data means information relating to a living individual who can be identified either from the data or from the data in conjunction with other information in the possession or control of the data controller. The data controller means a person who either alone or with others determines the purposes for which and the manner in which any personal data are or are to be processed. The data processor is the person who processes personal data on behalf of a data controller, but does not include an employee of a data controller who processes such data in the course of his employment. And the data subject, of course, is an individual who is the subject of the personal data. So the Data Protection Act applies to both the public and the private sectors, and of course to the Crown. However, it does not apply to personal data, which is obtained or used for matters relating to national security, information that is required by law to be made available to the public by the data controller, and information obtained, secured, and used for family, household, and recreational purposes. The Data Protection Act applies only to data controllers who are connected to the Bahamas. So that means as a data controller is an ordinarily resident, a company incorporated or registered in the Bahamas, or an individual who maintains an office or branch or agency or practice in the Bahamas and processes the data in connection with the business establishment. Or a data controller is not established in the Bahamas, but it uses equipment in this jurisdiction for processing data that is not restricted to data in the transit. So in order to protect the privacy of individuals and achieve the primary objectives of the legislation, the data controller must be satisfied of the following principles in relation to the data collection, the quality, and the use of personal data. The data should be collected and used fairly and by lawful means. The data should be accurate and kept up to date. It should be kept for specified purposes. It should be adequate, relevant, and not excessive in relation to the purpose for which it is kept. The data should not be disclosed in a manner that is inconsistent to the purpose for which it is kept. The data should not be kept for longer than is necessary, except where the data is historical, research, or statistical data. The data should be kept securely from unauthorized access, alteration, disclosure, destruction, or accidental loss. An individual has the right of access to personal data kept on him, except where the personal data is kept for the purposes of preventing, detecting, investigating offenses, prosecutions, tax collection, or assessments, or if such personal data is prejudicial to the security or maintenance of good order in prison or detention center. The right of access does not apply to legislation for the protection of individuals against financial loss arising from dishonesty or malpractice, legal professional privilege, matters relating to the protection of the international relations of the country, and statistical, research, or backup data. The Act provides that an individual with a right of rectification or erasure for personal data that is inaccurate. An individual is also afforded the right to prohibit the processing of personal data for the purposes of direct marketing. The data controller has a statutory duty of care to the data subject imposed upon them under Section 12 of the Act. And the data subject may bring a lawsuit against the data controller for breach of this statutory duty of care, if it is applicable, or where is it applicable. So notwithstanding that the Act provides protection for the disclosure of personal information, the Act also provides that protection can be overridden in the following circumstances: in the interest of national security, for the purposes of criminal investigations, prosecutions, and the collection of taxes, duties, and similar levies, the protection of international relations of the country, to prevent injury, damage, or loss to a person or property, any disclosure required by enactment of law or the enforcement of a court order, any disclosure required for the purpose of obtaining legal advice or required as part of legal proceedings, any disclosure made to the data subject concerned or to a person acting on his behalf, or any disclosure made of the request or consent of the data subject or person acting on his behalf. So the commissioner, the data commissioner, has the power to issue information, enforcement, and prohibition notices, appoint authorized officers for the purposes of inspection and examination, restrict the transfer of personal data to jurisdictions that do not provide equivalent individual data protection, and prosecute offenses under the Data Protection Act. Any comments so far on the duty of confidentiality and data protection?
Okay.
So there are other aspects of potential or actual legal liability that may be observed in contractual relationships between the financial institution and their client. Some of those things can be contributory negligence, exclusion clauses, consumer protection, misrepresentation and mistake, undue influence, tortious liability, negligent misstatements, breach of trust, and restitution. So in drafting and reviewing various client and service provider agreements, financial institutions must consider the following terms and conditions. So they will make sure that it contains who are the parties, the scope and the nature of the contract. They look at the duties, the obligations, the rights, responsibilities, prohibitions and restrictions. They look at the standard and the service levels, the minimum acceptable service provider characteristics, monitoring and reporting, transition requirements, the contract duration, termination and assignment. They look at the governing law, arbitration and litigation, exigencies and contingency provisions, contractual protections against liability, ownership, license, intellectual property, proprietary information, duration, dispute resolution, risk assessment, management and mitigation, indemnification, limitation of liability, contract inducements, terminations, assignment, foreign-based service providers, regulatory and legal compliance, and of course, they have to look at the risk that are inherent in that contractual relationship. That could include compliance risk, legal risk, liability risk, operational risk, regulatory risk, reputational risk. And of course, there are other risks that are inherent in the banker-customer relationship, because you also have financial risk, systemic risk, moral hazard risk. There are lots of risks. So effective action steps in managing legal and other risks in contractual relationships. The action steps that a financial institution should follow in ensuring the legal validity the effectiveness and risk management of its contractual relationships, and the agreements which underscore such relationships are the following. Specifically discuss and document client and service provider expectations, performance standards, and scope and ambit of duties, obligations, responsibilities, and rights. You have to review all existing client and other agreements for legal, regulatory, and financial compliance. You have to conduct internal audit of all legal and contractual documentation. You should review and address client complaints, particularly those based on contractual duties and performance standards. You should address and understand the specific contractual provisions and their relevance, effect, and impact internally and externally. You should conduct ongoing staff training on contractual documentation and implementation. Educate clients and all relevant stakeholders on the important provisions on the contract agreement and the nature and scope of the contractual relationship. Protect and preserve client information and financial institutions' confidential information, trade secrets, policies, and procedures. Ask the appropriate person, advisor, senior manager, or director if you don't know. The relationship of a financial institution and its client must neither be taken lightly nor treated carelessly. So let me ask you the question, looking at those bullet points there, which ones does your organization carry out in seeking to manage legal and other risk? Do you review and address all client complaints? Do you conduct ongoing staff training on contractual documentation?
I think that's for the bankers. This one really applies to me at this point. I say, I think that question was for the bankers. This one doesn't really apply to me yet.
No, this is for the bankers. The bankers went quiet. Kwame. Did he fall asleep?
I was thinking about it. I was happy.
Do you
Yes,
do
ma'am.
any of these things to manage legal and other risks?
Well, I in this class right now, so I guess they might. So I guess it's the training purpose behind it. We do conduct. Well, they are in the process of conducting internal and legal audits right now. They do review and address client complaints. Not necessarily based on contractual duties, but basically is on the performance and whatnot on our accounts or the client's accounts.
Okay.
They well, we try to educate the staff and everybody in connection with it. So I mean, for the most part, at least where I work, we try to do most of them. Now I cannot say from the other side for all of them, but you know, I can say for most of them we usually do.
Okay. So now you'll be able to do some training.
Yes, ma'am. Hopefully.
Hopefully. You should be able to do some training, some basic training.
You know, you have to be a good public speaker, and you know, I'm not that.
Well, you'll have to learn.
Yes, ma'am.
Okay. So normally the legal issues which arise in the banking law often relate to some breach of a duty. and the recognition of the rights of the parties of the banker-customer contract. The legal defenses and remedies available to the parties to the banker-customer contract are dependent upon the action of the parties in operating the account, complying with the bank's mandate, and mitigating risk and/or loss in banking transactions involving the parties. So whether in the role of the plaintiff or defendant, some of the important considerations that must be taken by the bank and the customer in commencing or defending a civil action for breach of contract or negligence, the tort of conversion, or some other civil wrong are the cost of the action, the time involved in adjudicating the matter, publicity, convenience or inconvenience, and of course, the need for a ruling. Banks are often advised to take a practical approach to resolving legal issues before proceeding to commence an action or initiate legal proceedings. All facts should be investigated, reviewed, and analyzed in order to determine the strengths and weaknesses of each party's legal and/or commercial position in the context of the duties and rights of the parties based upon the banker-customer contract. So credit risk. Credit risk is defined as the risk that one party to a financial contract will fail to discharge an obligation and cause the other party to incur financial loss. Wikipedia says a credit risk is the risk of default on a debt that may arise from a borrower failing to make required payments. The central bank in its guidelines states that credit risk is the risk of financial loss, despite realization of collateral security or property, resulting from the failure of a debtor to honor its obligation to the licensee. So exposure to credit risk has been one of the leading causes of the myriad of problems that many banks face in recent times, due to lax credit standards for borrowers and their counterparties, poor portfolio risk management, or weak systems and controls for credit risk identification, assessment, mitigation, and management. So let me ask you now, based on the cases that we have gone through, what do you think are some of the reasons why we have so many defaults from the bank side of it?
Ms. Archer, I would say based on a lot of the cases, I guess, poor with respect to the bank's research or researching the clients or getting the necessary information. The clients are not really, they don't have the ability, most of them didn't have the ability to repay on the onset. Based
Exactly.
on the history that they presented, they didn't they probably didn't have the financial statements, but because they were holding collateral in connection with it, the banks just decided to go ahead and give the loans or give the mortgages based on that.
Okay, and we saw that in the majority, if out of all of them, you would say about 80%, that was the reason, right? From the very
Yes, ma'am.
beginning.
But 70.
Yeah.
I've been reading through some of the stuff, and I've noticed that's been a lot of the thing, because a lot of those in my limited credit history, I'll tell you, I'd think twice about giving those personal loans.
Yes, but we came to that conclusion when we were discussing each one. When we looked at the issues that they had in paying the loan, we said they shouldn't have gotten the loan from the first place.
Yes, ma'am. So I guess it's the credit policies or the risk policies that was implemented or that was in place with the organizations at the beginning.
Right. And so with all of these default, that is something, again, that the organization has to look at. And have they done that? Have they looked at their credit policies? Because when you look at the cases that we read, how did the organizations mitigate against that risk? Because you're not giving loans in order for them to default. That's not the purpose. So how do they mitigate against that risk?
by putting more stringent controls in place with respect to the clients then when they're coming in, ensuring like the job letters or that they've been on the job more than 2 years and they have job stability, by ensuring that the debt service and whatnot is correct and they're not exceeding the 45%, which is basically standard across the board with all of them, by doing proper job checks with the establishments. I guess it's things like that that they put in place to try to mitigate it.
Okay. And so a lot of institutions would have put those in place, but yet we still have defaults. So how do you mitigate against the risk?
Well, most banks now try to mitigate with it by ensuring that they get a salary deduction from the clients or from the individuals from their jobs at some point. I mean, at the beginning, to ensure that the payments come in and that they don't have that issue.
So what do you do when you do get a payment slip and they work for 5 years and then they're let go? How do you mitigate against that risk?
Well, that's going by holding collateral, I guess. Well, that's the collateral portion of it. Because
Mhm.
I guess if you have collateral to how should I put it, collateral to ensure that you get your funds back, you should be okay.
Yes. And then of course you have the Home Protection Act that comes in. That gives you an extended time before you can get your funds back.
Yes, ma'am, it does.
So that's another area you have to mitigate against. That time frame, that process.
Well, during the process, you once you could mitigate again, but you could shorten the time by the minute they start the default by starting the process early.
Yes.
So that at the end of the day, it wouldn't be a problem when well, it's still going to be some time, but it wouldn't be as much time if you, especially take for instance, if the Homeowners Protection Act say that, hey, look here, you should work with the clients before you take the house. You could start you notice that the clients get in default. You could actually start right away by issuing them with let's say a payment agreement letter where you put them under repayment and say, okay, yeah, I agree to pay this or whatnot, and you do this maybe why I say 60 days or maybe why I say 30 days past due. So at the end of the day, you mitigate the time based on the situation.
Right. See, because you always got to look at it from two eyes. One is the customer, but you are an employee of the bank. And so you have to look at how is the bank going to mitigate its risk and also decrease the financial loss. And that's the key to all of this. So you have to look when you're granting a mortgage or any loan, you have to look at what are the risks if I grant this loan. Because it's not looking at it at this point in time, it's looking at it in the future. What if this happens? What if that happens? Because you'd hate to be a loan officer and you've issued 10 loans and 8 of them are bad. That becomes a poor reflection on you.
Agreed.
Because you see a lot of people go into loans. They want to be a loans officer, but the performance is not there because they're not looking at what are the risks. How do I mitigate against those risks?
But again, some institutions, you got to understand, Ms. Archer, some institutions, that may be an acceptable risk for them. Because when they put their criteria in place to say that, okay, you have to be working on the job 2 years or more, as long as you're within that guideline or that standard or whatever they put in place, whether you lose your job a year later or 5 months later or whatever the situation is, that's something that they would basically said, okay, at the end of the day,
They're willing to. that risk.
They're willing to accept that risk.
Mm-hmm. Yep. But they have to have tight controls in place.
Yes, ma'am.
Yeah, for that kind of risk. So effective credit risk management are as follows, the principles for it. Establishing an effective credit risk environment. Operating a sound credit granting process. Maintaining an appropriate credit administration, measurement, and monitoring process. Credit risk management is one of the primary functions that relate to mortgage lending and the performance of banking services in relation to profitability and increased shareholder value within financial institutions. Credit risk, compliance risk, financial risk, liquidity risk, operational risk, and regulatory risk are all related to developing an effective system of credit risk management, particularly in relation to mortgage lending. So compliance risk is defined as the risk of legal sanctions, material financial loss, or loss to reputation the bank may suffer as a result of its failure to comply with laws, its own reputation, the code of conduct, and standards of best good practice. So what we're saying here is that in addition to credit risk, when you're dealing with clients in this banker-customer relationship, and especially with the granting of mortgage lending, there are other risks that are inherent in this business that you have to be cognizant of. You have financial risk. It is an umbrella term for multiple types of risk associated with financing, including financial transactions that include company loans and risk of default. Risk is a term often used to imply downside risk, meaning the uncertainty of a return and the potential for financial loss. Liquidity risk is the risk that a company or bank may be unable to meet short-term financial demands. This usually occurs due to the inability to convert a security or hard asset to cash without a loss of capital and or income in the process. Legal risk is the risk arising from failure to comply with statutory or regulatory obligations. Liability risk is a risk that to a company arising from the possibility of liability for damages resulting from the purchase, ownership, or use of a good or services offered by that company. Liability risk can be identified and mitigated through careful product design and testing, but may also be inherent in the nature of the product to some extent, as in the case of automobiles or pharmaceutical supplies. Operational risk is the prospect of loss resulting from inadequate or failed procedures, systems or policies, employee errors, system failures, fraud, or other criminal activity. Any event that disrupts business processes. Regulatory risk is generally defined as the risk of having the license to operate withdrawn by a regulator or having conditions applied that adversely impact the economic value of an enterprise. And reputational risk is a risk of loss resulting from damages to a firm's reputation in lost revenue, increased operating, capital or regulatory costs, or destruction of shareholder value, consequent to an adverse or potentially criminal event, even if the company is not found guilty. So in addition to credit risk, you have to consider all of these other risks. All of them come together to make an organization profitable. So in a financial institution, the main activity is lending. And for mortgage lending, there are risks. And your policies and procedure must cover all of the risks that are inherent in that business. And in order to mitigate against that risk, you must have policies and procedures that are in place. And you must have a process in place for granting loans and also dealing with delinquency. Any questions or comments? No questions or comments? Everybody is too quiet tonight.
I don't think this one applied to me, so I just got to set it out.
Oh, I see. Oh, yeah, because you're not a banker. All right, so next week, when we come, we'll do the last chapter. And after we finish the last chapter, we will do our review for the exam. So that would give those who are taking it early at least how many days? You'll have sufficient time. You'll have a week and a half to study. Any preferences for the exam?
Yeah, open book.
No, that won't be happening.
It's worth an ask.
Yeah, right. You know you don't need an open book, so don't say it. I like scenario questions, just like the cases. It's good exercise of the brain. Any objections?
How many scenario questions are there going to be?
5.
Okay, and you could give us an idea of what they're going to be like.
Yes, I will. On Monday.
Thank you.
Why are you laughing? Why is there laughter? I will tell you what areas to study for the exam.
Thank you. Greatly appreciated.
Yeah.
Appreciate it.
What I mean. I'm trying to see if I should just throw in some, like this chapter we just did. I could give a question from this chapter. I could. You prefer to have just 5 mandatory questions, or you prefer to have 2 mandatory and choose out of the rest?
In the multiple choice
Yeah, that
questions,
was, no, the latter was fine, where we could choose the other 3.
Okay. All right. But I would give like 2 mandatory questions to make sure you understand the concept of mortgages. And then you could choose. Okay.
Right.
So I hear someone say multiple choice. I'm saying multiple choice.
me.
You
Come
sure
on.
you want?
I want the easiest thing possible, man. I still having difficulty understanding what it is, what I reading and doing. I ain't gonna lie.
Couple multiple choice will hurt.
Okay, so this is how I will design it. Let me write it down as I speak. I will give you 2 mandatory questions, right? That's how I'll design it. I'll give you 2 mandatory questions. Then you can choose 3 questions out of 5. Right? And so that'll be part A, part B, and then we'll have a part C. And part C would be 20 multiple choice questions. So you could choose to do 2 questions out of B and the multiple choice in part C. How that sound?
Okay, that's
Okay.
cool.
So can choose to do 2 questions out of B?
And then do part C, which is the 20 multiple choice. You have to do part A. Part A is 2 mandatory questions.
Okay,
So after you finish doing part A, in part B, you have to choose 3 questions out of 5. But you can choose, instead of 3 questions, choose 2 and then do part C.
Okay.
okay.
That sounds good?
Yeah.
So you get a chance on the 20 multiple choice questions to get as much as you could get. Yeah, that sounds good. Anybody else have any suggestions? Oh, that sounds good.
That's perfect.
Okay, all right. So that's next week, and I'll give you the areas that the exam
Alright.
covers on next
Okay.
class.
That
Okay.
sounds good. Yes,
All
ma'am.
right.
Okay, ma'am.
All right. So have a good evening.
Okay, you do the same.
Start over your notes, those who are taking it early.
Yes, ma'am. And thank you.
Yes. Good night. Good night, everybody.
Good night.
Good night.
Good night.
Good night.